Welcome to our presentation on the history of special education in public schools. It is our hope that at the end of this presentation you will understand more of how the special education laws have evolved and improved through the years for the betterment of our students. At the beginning, when the country was founded, the Constitution provided no rights or guidelines for education in the U.S. So education doesn't fall under the federal government originally. It fell under the states. Each state decided what they were going to do and how they were going to educate their children. In the late 1800s, each state decided that they wanted to have a public who knew how to vote and what to vote for, and so they could make educated decisions. To do this, they needed to have a population that had an education. So each state devised their own set of laws for compulsory public education to ensure that all of their children would be well educated in a quality setting. However, just like now, they still had children with disabilities. They weren't sure what to do with these children, though. So they began to expel them. And when they were challenged in this in court, the courts decided, like in the case of Watson versus the City of Cambridge, that if a child could not function in the school system the way the other children did, if they were weak in mind, if they couldn't understand the curriculum, if they could not sit and behave properly, then it was the school's right to expel them. Some states opened up separate schools so that you would have a school for the deaf, but in this school you would also have children with other disabilities as well. If they could not meet the standards of the regular classroom, they were either expelled or placed in these smaller schools. That was up until the White House Conference of 1910. This was the first eye-opener in the United States to how the children with disabilities were being treated. This came from the parents. The parents began to advocate really heavily for their children. And this made it to the White House and got the president's attention. So they had a meeting to decide that we needed to do something about this. So from 1910 to 1913, they began to do studies and conduct research to find out how these children were being treated and what they could do to help them. This was a very slow process because each state still had the authority over their own educational system. So it was kind of filtering down into the states of, this is a problem. We do need to educate our children with disabilities, but what is the rule? What is the guideline? How do we go about doing this? After the conference, they moved toward not expelling students with disabilities, but rather to include them in the school in a segregated fashion. This came to light with the Civil Rights Movement. When the Civil Rights Movement came in, they realized that it wasn't just the blacks that were being segregated. It was also the children with disabilities. So this opened the door for new legislation so that the children could be a part of the schools. In the case of Brown versus the Board of Education, that was a segregation matter for the colored people, but it opened the door for our people with disabilities as well. What happened was, after this, we had several acts come in that were federally mandated that they could do it Because of the Brown versus the Board of Education, now they had the freedom to enact new laws that would help these students with disabilities. Under the civil rights laws, you had the Rehabilitation Act of 1973. You also had education for all handicapped children. What this did was offered children equal quality education no matter what their disability. It was still, again, a slow process. In the 1990s, under the same authority of the Civil Rights Act, you had the Americans with Disabilities Act was enacted. At that same time, you had the Individuals with Disabilities Act. There was our first glimpse of IDEA. Through these, children with disabilities would be given better education and given more opportunity to have a quality education. And more guidelines were being set into place as far as how the children could be disciplined, how much time they had to spend in the classroom. All of these little details were starting to be ironed out. In 1997, they had amendments to the IDEA, and in 2004, it was really settled and the reauthorization of IDEA was set in. In 2004, they decided, hey, we're going to have an individual education plan. They also decided that the children were going to be found and evaluated, and that they were going to be put in the least restrictive environment. All these laws come from the reauthorization of IDEA in 2004. Each year, all these laws are being re-evaluated so that the parents can benefit and the children can benefit. One new law that has come into effect is FERPA, which we're going to look at in just a second. One case in 2017, you had a family that took the District of Columbia to court. In the preschools there, they were seeing many children that are not getting evaluated. Under the IDEA laws of 2004, children between the ages of 3 and 5 should be watched, evaluated, tested to see if they need to be put in the special education program. That was not happening in this specific district. In this school system, they found over 200 children that had been looked over. They had not been evaluated. They were not doing their job. So a family was able to take the District of Columbia to court and bring this to light so that now that school system realizes they have to follow the rules, they have accountability, and they're going to be able to reach a lot more children now. Under FERPA, the Family Educational Rights and Privacy Act, families have the right to have all of their information secure. A school cannot share a child's information without the parent's permission. This has been further specified to be that a child's picture cannot be on a website, cannot be on Facebook, cannot be posted anywhere without parents' consent, and especially with the special education children. They don't want their identities to be stolen or tampered with, so they keep all of their information tightly secure. Their names cannot be on the wall outside the classroom. Their pictures cannot be posted publicly without parental consent. This has been so successful that all of the cases recently for FERPA have been people trying to access certain educational information, even for themselves. They have to go to court and say, I need permission to get this information for this student for this purpose. FERPA is very good at protecting the children and the family's identification. We have hoped that you have enjoyed our presentation on the laws. As you can see, today's laws are much stricter and much more refined than what we had in the past. Thank you.